Welcome to UGC EPG Pathashala on Human Rights and Duties. My name is Professor Murthy. I am the Executive Director for the Center for Human Rights Studies, OP Jindal Global University. In this module, we will further take up the international law with regard to the prohibition of torture. At the end of this module, you will gain a deep understanding of the evolving concept of torture in the international law. This module also will provide you an oversight into the jurisprudence evolved by the international treaty bodies as well as regional mechanisms. With the evolution of international human rights law, the practice of torture has been held to be at variance with the notion of civilized life. It was because of this realization that the legal prohibition of torture was made absolute. It is one of those few norms under international law that has attained the status of jus cogens, sharing this position with only a handful of other inviolable rules, including the prohibition of genocide and slavery. Though prohibition of torture has been made absolute, it still persists in many parts of the world. As a result, the international law experts have been struggling to bring an end to this terrible practice through legal instruments and procedures under the realm of international law. There is a growing body of jurisprudence in this area now. And how did this jurisprudence come about? It stemmed from the functioning or the orders passed by various international treaty bodies as well as regional mechanisms. For instance, there are several institutions under the United Nations which are particularly focusing on the complaints of torture, such as the Human Rights Committee, the Committee Against Torture, etc. It needs to be mentioned that these bodies have been relatively more effective in addressing the issue of torture due to the institutionalized mechanism. The individual complaints mechanism of these treaty bodies empower an individual to obtain from an international body redress and justice against a state that has violated the universally recognized human rights norms. These bodies serve a critically important function in situations where domestic legal systems have failed to hold perpetrators to account for their actions. This module seeks to provide a clear understanding of the evolving concept of torture in the international law. Torture and other cruel, inhuman or degrading treatment or punishment is prohibited, if you see, by the Universal Declaration of Human Rights as well as under Article 7 of the International Covenant on Civil and Political Rights that was adopted in 1966. Article 7 of ICCPR is supplemented by Article 10, which recognizes a right of humane treatment for persons in all forms of detention, a particularly vulnerable group of people. The rights in the ICCPR are supervised and monitored at the international level by the treaty body called Human Rights Committee. Torture and other cruel, inhuman or degrading treatment is also addressed and prohibited by a thematic treaty, that is Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, that was adopted by UN in the year 1984, and it is monitored and supervised at the international level by the Torture Committee. Prohibition of torture under international law instruments will take up now. All international instruments that contain the prohibition of torture and ill treatment recognize its absolute, non-derogable character. For instance, in the ICCPR, the prohibition which is contained in Article 7, which states no one shall be subjected to torture or to cruel, inhuman or degrading treatment or punishment. And if you see Article 4.2 of the ICCPR, it says the prohibition against torture is non-derogable even in times of public emergency which threatens the life of a nation. Even in those trying, testing times, one is supposed to uphold this right. Article 7 of the ICCPR has been heavily discussed in the Human Rights Committee. It has issued several views. For instance, the General Comment 20 made the following observation, and I quote, "The text of Article 17 of ICCPR allows of no limitation. The committee also affirms that even in situations of public emergency, such as those referred to in Article 4 of the Covenant, no derogation from the provision of Article 7 is allowed and its provisions must remain in force. No justification or extenuating circumstances may be invoked to excuse a violation of Article 7 for any reasons." The Committee Against Torture has been established under Article 17 of the Convention on Torture. Its functions have been set out in Part 2 of the treaty. The primary function of the Torture Committee is to oversee the implementation of the UN Convention Against Torture. It takes a number of functions including review of state party reports, individual complaints, etc. Now let's look at some of the major cases handled by the treaty bodies. In Volane versus Finland, on the question of whether an act falls within the scope of Article 7 of ICCPR, the Human Rights Committee said it will depend on all the circumstances of the case, the duration and manner of the treatment, its physical or mental effects, as well as the sex, age and state of health of the victim. In another case, Grilli Mota versus Uruguay, the Human Rights Committee gave the following elements which would fall within the definition of torture: systematic beatings, electric shocks to the fingers, eyelids, nose and genitals when tied naked to a metal bed frame or in a coiling wire around fingers and genitals, and burning with cigarettes, extended burns, extended hanging from head and or leg chains, often combined with electric shocks, repeated immersion in a mixture of blood, urine, vomit and excrement, what is known as submarino, standing naked and handcuffed for great lengths, threats, simulated executions and amputation. All of these have been regarded as torture. In Kaliova versus Tajikistan, beatings to induce confession as well as beatings of and ultimately the killing of the victim's father on police premises was held to fall within the definition of torture. Now let us turn our attention to those cases involving cruel and inhuman treatment. In Linton versus Jamaica, the victim was beaten unconscious subjected to a mock execution and denied appropriate medical care. In Bailey versus Jamaica, the victim was beaten repeatedly with clubs, iron pipes and batons and left without medical care for his injuries. In Hilton versus Jamaica, the victim was severely beaten by prison warders and also received death threats from them. Yet in another case, Daedric versus Jamaica, the victim was imprisoned in a cell for 23 hours per day without mattress or bedding, integral sanitation, natural light, recreational facilities, decent food or adequate medical care. All of them have been held to be constitute torture, cruel, inhuman, degrading treatment or punishment. The Human Rights Committee has been proactively addressing the use of excessive force by police. The concerns of Human Rights Committee were best expressed in the following statement with regard to the United States of America. Quote, "The committee reiterates its concern about reports of police brutality and excessive use of force by law enforcement officials. The committee is concerned in particular by the use of so-called less lethal restraint devices such as electromuscular disruption devices or EMDs. In situations where lethal or other serious force would not otherwise have been used, it is concerned about information according to which police have used teasers against unruly school children, mentally disabled or intoxicated individuals involved in disturbed but non-life-threatening behavior, elderly people, pregnant women, unarmed suspects fleeing minor crime scenes, and people who argue with officers or simply fail to comply with police commands. In most cases, the responsible officers being found to have violated their department's policies." Unquote. A really great indictment indeed. The Human Rights Committee has taken cases of ill treatment in custody very seriously, as they fall within the scope of Article 7 of the Convention Against Torture. In White versus Madagascar, a person was held for 10 months incommunicado, including solitary confinement, chained to a bed spring for 3.5 months with minimal clothing and severe food rations, followed by a further month's detention incommunicado in a tiny cell, followed by detention with another in a 3 by 3 meter cell without external access for 18 months. This was characterized as a case of torture. In Wilson versus Philippines, the complainant was subjected to ill treatment in the following manner. There he was beaten and ill-treated in a concrete coffin. This 16 by 16 foot cell held 40 prisoners with a 6-inch air gap some 10 foot from the floor. One inmate was shot by a drunken guard, and the other had a gun placed to his head on several occasions by guards. The bottom part of his feet were stuck by a guard's baton, and other inmates struck him on the guard's orders. He was ordered to strike other prisoners and was beaten when he refused to do so. He was also constantly subjected to extortion by other inmates with the tacit acceptance, and in some cases on the direct instruction of the prison authorities, and beaten when he refused to pay or perform the directed acts. These acts were held to be violative of Article 7 of the ICCPR. Now let's take up some cases involving gender. Specific forms of torture or ill treatment. The Human Rights Committee has implied that forced abortion, forced sterilization, female genital mutilation, domestic violence against women, and a lack of access to safe abortion for women who have become pregnant as a result of rape can give rise to violations under Article 7 of the ICCPR. In addition to convictions for rape, male defendants who raped women have been convicted of torture as a war crime and a crime against humanity by the Yugoslavia Tribunal, while a defendant who committed acts of sexual violence against women was convicted by the Rwandan Tribunal of inhumane acts as crimes against humanity and of causing serious bodily or mental harm to members of the group as acts of genocide. Now let us look at cases involving corporal punishment. The Human Rights Committee has stated that the prohibition of torture and ill treatment under Article 7 of the ICCPR must extend to corporal punishment, including excessive chastisement ordered as punishment for a crime or as an educative or disciplinary measure. And in this regard, Article 7 protects, in particular, children, pupils and parents in teaching and medical institutions. Now let us look at medical experimentation. Article 7 of the ICCPR states that no one shall be subjected without his free consent to medical or scientific experimentation. The inclusion of a specific reference to this form of torture or ill treatment was a reaction to atrocities perpetrated by Germany under Nazi rule, where prisoners had been subjected to infection, surgical operations, anatomical research and other experiments, usually ending in death. In keeping with this notion, biological experiments are specified as a form of torture or inhuman treatment in the 4 Geneva Conventions of 1949, punishable as grave breaches of those conventions, and unwanted, unwarranted medical or scientific experiments are also prohibited. In Vienna Acosta versus Uruguay, the Human Rights Committee found that psychiatric experiments and tranquilizer injections against the will of imprisoned victim constituted inhuman treatment in violation of Article 7 of the ICCPR. The United Nations Special Rapporteur on torture and other cruel, inhuman and degrading treatment or punishment stated the following with regard to the role of CAT, with regard to the role of the Torture Committee in combating torture. He said, a thorough analysis of the travaux preparatoires of Article 1 and 16 of the Convention, as well as a systematic interpretation of both provisions in light of the practice of the Committee Against Torture, leads one to conclude that the decisive criteria for distinguishing torture from cruel, inhuman and degrading treatment may best be understood to be purpose of the conduct and the powerlessness of the victim, rather than the intensity of the pain or suffering inflicted. Let's look at gender-specific forms of torture or ill treatment. The Special Rapporteur on Torture has referred to acts of rape, sexual abuse and harassment, virginity testing, forced abortion and forced miscarriage as gender-specific forms of torture. The UN Special Rapporteur on Violence Against Women has referred to cultural practices such as female genital mutilation, honor killings, bride burning, and any other form of cultural practice that brutalizes the female body as practices which involve severe pain and suffering and may be considered torture-like in their manifestation. Now let us see what the regional mechanisms have done. Let's take up the European Court of Human Rights. It has done significant work in this area, and as a result, today there is a growing influence of the jurisprudence regarding torture cases. The European Convention for the Protection of Human Rights and Fundamental Freedoms embodies all those rights and freedoms which are to be afforded to people, and subsequently ascribes positive and negative obligations upon states parties to ensure respect for those rights. The prohibition on torture and other forms of ill treatment is enshrined in Article 3 of the European Convention, which simply states like this: no one shall be subjected to torture or to inhuman or degrading treatment or punishment. Article 3 of the European Convention must be read together with Article 15, which states that no derogation whatsoever can be made from the provisions of Article 3. Thus, the European Convention imposes an absolute prohibition on torture, inhuman and degrading treatment or punishment. While other international and regional treaties define these torture and other such prohibited acts, Article 3 of the European Convention does not ascribe any definitional characteristics to torture, inhuman or degrading treatment or punishment. Accordingly, a complex and an extensive body of jurisprudence has emerged from the European human rights judicial bodies based at Strasbourg in order to determine the definitional aspects of these forms of abuse. Now, let's take up some leading European cases on torture. The Greek case, it was considered by the European Commission of Human Rights, and it involved the conduct of Greek security forces following the military coup in 1967. This is a landmark case because the European Commission adopted a general definitional approach which distinguished the three prohibited acts: torture, inhuman and degrading treatment or punishment. The most significant contribution of this judgment was that it held that defining characteristic of torture was the purpose for which the act was carried out rather than the severity or barbarity of it. All torture must be inhuman and degrading treatment, and inhuman treatment also degrading. So the notion of inhuman treatment covers at least such treatment as deliberately causes severe suffering, mental or physical, which in the particular situation is unjustifiable. torture has a purpose, such as the obtaining of information or confessions or the infliction of punishment, and it is generally an aggravated form of inhuman treatment or punishment. Treatment or punishment of an individual may be said to be degrading if it grossly humiliates him before others or drives him to act against his will or conscience. In other words, while torture was often perceived or seen as an aggravated form of inhuman treatment, this was not the distinguishing element of an act of torture. Torture was rather the purposive use of inhuman treatment. This distinction, which was first discussed in the Greek case, was further developed and considered by subsequent decisions and has been refined significantly. Let's now take up Ireland versus UK case. This case concerned the treatment of Irish Republican Army or IRA suspects by the UK troops in Northern Ireland. This case was brought by the Irish government against the United Kingdom, alleging, among other things, that the methods of interrogation using the 5 techniques: sleep deprivation, stress positions, deprivation of food and drink, subjection to noise, and hooding constituted a breach of Article 3 on prohibition of torture. The European Court held that as a result of the use of the 5 techniques resulted in, if not actual bodily injury, at least intense physical and mental suffering, and also led to psychiatric disturbances during the interrogation, and therefore fell into the category of inhuman treatment, but the practices did not occasion suffering of the particular intensity and cruelty implied by the word torture, thereby overturning the earlier decision by the European Commission that the practices did amount to torture. In Iodine versus Turkey, the European Court held that in certain particular circumstances, rape can cause severe mental and physical suffering so as to result in a situation amounting to torture. The rape of a detainee by an official of the state must be considered to be an especially grave and abhorrent form of ill treatment, given the ease with which the offender can exploit the vulnerability and weakened resistance of the victim. In addition, rape leaves deep psychological scars on the victim which do not respond to the passage of time as quickly as other forms of physical violence. Against this background, the court is satisfied that the accumulation of acts of physical and mental violence, especially the cruel act of rape to which she was subjected, amounted to torture in breach of Article 3 of the European Convention. The European Court defined the threshold of torture when the case involves rape. The crucial test is severe enough. The court also said that it could have reached this conclusion on either of the grounds taken separately, that is, the allegation of torture due to the rape and the allegation of torture due to the other forms of physical and mental violence inflicted. Accordingly, it is arguable that in certain circumstances, an act of rape alone can amount to torture. In Selmoni versus France, this case is significant from the point of view that it addressed and discussed the definition of torture given in the Article 1 of the United Nations Convention Against Torture. The court, citing Article 1 of the UN Torture Convention, noted that it defines torture as any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for a specific purpose, the court stated that having considered the suffering inflicted amounted to inhuman treatment, it remains to establish in the instance case whether the pain or suffering inflicted can be defined as severe within the meaning of Article 1 of the UN Convention Against Torture. However, in order to determine the level of severity, the court returned to the approach established under Ireland versus UK, that this is relative and depends on all the circumstances of the case. In HLR versus France, this case was particularly significant for the simple reason that it discussed the cases where even non-state actors were involved in case of torture. Up until this point, the cases of torture were only confined to state authorities. However, in this case, the Colombian national was at the risk of being tortured at the hands of drug traffickers after being deported. Even though in this case the threat of torture was coming from non-state authorities, the court held the following: owing to the absolute character of the right guaranteed, the court does not rule out the possibility that Article 3 of the European Convention may also apply where the danger emanates from persons or groups of persons who are not public officials. The reasoning was further upheld in the case of A versus UK, where the court held the following with regard to the role of non-state actors. The court considers that the obligations on high contracting parties under Article 1 of the Convention to secure to everyone within their jurisdiction the rights and freedoms defined in the Convention, taken together with Article 3, require states to take measures designed to ensure that individuals within their jurisdiction are not subjected to torture or inhuman or degrading treatment or punishment, including such ill treatment administered by private individuals or non-state actors. In conclusion, today there is an expanded understanding of the term torture through a wealth of jurisprudence evolved by UN treaty bodies and other regional mechanisms. It is not merely confined to a custodial setting, but it is also includes sexual violations, it includes forced medical experimentation, it includes racial discrimination, and so on and so forth. Thank you.